Well, government MPs are worried for the impartiality of the High Court in the wake of last week's decision that held that racial identification, in this case identifying as Aboriginal, trumps any application of the Constitution or migration law. And while the detail of these two related cases is worth discussing more broadly, for me tonight it's the issue and the growing instance of judicial activism that's most concerning. Now, joining me is someone who has had the rare experience of working on the inside of the High Court as an associate to a High Court judge and is now a Queensland Senator. She's taking up the issue of judicial activism ahead of two upcoming vacancies on Australia's highest court, with the retirements of Justice Geoffrey Nettle in December and Justice Virginia Bell in March. And the government, of course, makes these recommendations for appointment to the Governor-General, and then we're away. LNP Senator for Queensland, Amanda Stoker, joins me now. Amanda, let's start, if we can, Senator. I'm interested both in your perspective, obviously, as a lawmaker in the Parliament, but critically, your experience in the High Court as an associate, which to people at home is a bit like a chief of staff or an advisor to a judge. What did you make of the decision last Tuesday?
I'm really disturbed by last Tuesday's decision because, in essence, it put a race-based limit on the ability of the Commonwealth to make legislation in relation to what's called the aliens power, which is essentially the rights of the Commonwealth government to deal with people who aren't citizens. And that is a really disturbing thing. The idea that there is a separate class of people dealt with by our Constitution purely on the basis of their race, an attribute they can't even slightly control, is something I think that runs antithetical to the culture we want to build here in Australia, where we are so egalitarian, where we are all equal and able to get ahead. But what is problematic about it from a judicial method perspective is that it is so activist. Now, when we talk about judicial activism, we're talking about whether or not a judge believes it is the right thing to do to stray simply from interpreting laws and interpreting the Constitution as it was intended to be at the time it was drafted, that's how one should do it. An activist believes that it is okay to stray into matters of lawmaking and policy. Now, that's a problem because that's for parliaments to do. And if we want to change the Constitution, the right way to do it isn't to allow some fancy but intriguing argument to persuade some very bright judges. The right way to change the Constitution is to take a referendum to the people of Australia who own that Constitution.
And you have a lot of comfort in what you just said there, because it comes also from Justice Kiefel, who's the Chief Justice of the High Court. That's very much her view. I want to quote her exactly, because she says, in Kiefel's view, it would be quite wrong of the court to seek to determine who might be an alien under the Citizenship Act. Quote, such an approach would involve matters of values and policy. It would usurp the role of the Parliament. But that's precisely what the court tried to do, or in fact did, in a split judgment, 4-3. It's now a majority judgment, obviously, and that will hold out as precedent. Is there a concern that this will extend to other areas of Commonwealth law, whether there'll be an Aboriginality test applied to welfare entitlements or anything else that the Commonwealth Parliament, your Parliament, might legislate for? But importantly too, so that people understand the distinction between activist judges, and we often hear the term black letter law, 3 of these appointments in that majority of 4 were from your predecessor in the Queensland Parliament, George Brandis. You took his seat when he retired and went to London as our High Commissioner. That's a worrying too.
It's not ideal, and it highlights the importance. It's a very good reminder, with 2 vacancies coming up over the next just over a year, that we need to be very careful about understanding the beliefs about judicial decision-making of the people who are being appointed. Now, there's some people who will try and glibly say, this is just another senator trying to get political about judicial appointments. But we've got to get real here. Labor always appoint hard left activists into these types of roles because they think judicial activism is a good thing. They like the idea that law can evolve through the actions of the elite people who know better. I find that really objectionable, and it is really important that at this point in the process, any people who are being considered for these roles aren't being screened for their politics. That's not what I'm suggesting. They should be screened for their judicial method. So when people talk about a constitutional conservative, they're not talking about somebody who likes to vote for the Liberal Party. They're talking about somebody who is going to be very strict in their fidelity to the words of the Constitution as they were intended to be, and not stray into policy and lawmaking of their own.
Do you think that's going to be the focus of the Attorney-General, Christian Porter?
Well, it needs to be, because it's core to the role. There are other considerations that come into play when you're deciding whether or not a person is a suitable appointment. There's always considerations of the state of origin, because being the court that is the final court of appeal in a federation, there's always a desirability to have people from a range of different states. It is important to make sure they have a good judicial decision-making method, but it's also important to make sure they've got a certain level of nous, and I hesitate to use the word political, but oftentimes you're dealing with a panel of judges, whether it's 5 or 7, and they need to be able to work together to find areas of agreement so that they can try and form majority judgments. So you want somebody who can build consensus around good ideas. And in a sense, that's a political skill. So while I'm not suggesting we should be appointing political people, they've got to have the social skills needed as well as that legal skill
you're saying
to be able to do the job well.
Let's avoid Mark Dreyfus getting a clip of you tonight. What you're talking about is not political partisanship. You're talking about small p politics, or the social skills, almost negotiation skills that you'd expect,
That's right.
you'd hope senior executives would have, senior judges would have.
Yeah, it's about human relationships and how you can build consensus around ideas, including legal ones.
All right, well, I hope, at least behind closed doors, I appreciate you're on the backbench, but I hope you speak loudly when you return to Canberra on this issue. You've got rare experience, as I said, having that role previously inside the High Court, and I hope you listen to Amanda Stoker, perhaps, and have more sway than less sway actually than the person you took the seat from, because he had, I was there at the time, a lot of sway, and these aren't good appointments, I have to say, not good appointments. Amanda Stoker, thanks for your time.
Thank you, Peter.